that the employer's PRSI exemption scheme will remain in place until the end of this year for businesses that take on workers under this scheme. The programme for government provides for the establishment of a new National Employment and Entitlement Service under the management of my department, with the objective of integrating the employment support services currently being provided by my department and FOS into a single service. The integration of employment services and related benefit payment services through the Department of Social Protection will provide a one-stop shop for people wishing to establish their benefit entitlements, seek employment and seek advice about their training and work experience options. A key objective of the new service is to offer users a high level of personalised employment support and to prioritise the provision of more intensive support for those most at risk of long-term unemployment. Put briefly, it means that the day that people sign on for a social welfare payment is the day that they also start the road to looking for options and opportunities in relation to getting back to work, going into training, going into education. That is critical to the reform of the system. A number of pilot projects have already begun to develop a case management approach to identify those most at risk of falling into long-term unemployment and to provide appropriately tailored responses to their needs. These pilot projects will be completed and evaluated in the coming months, after which approaches will be developed for their rollout nationwide as part of the new National Employment and Entitlement Service. In order to help break the cycle, as I said, where job seekers are unable to get a job without suitable experience or gain the necessary experience to get a job, the government is introducing a new national internship scheme. This new scheme, which will start in July, will provide up to 5,000 work experience places for job seekers in the private, public, community and voluntary sectors. Internships will range from 6 months to 9 months, and during this time participants will receive a top-up allowance of €50 a week in addition to their existing social welfare entitlement. The National Internship Scheme will apply to people entering the labour market after education or training. It will also apply to unemployed workers whose existing skills are no longer in demand. Providing pathways to employment or re-employment is vital. This scheme will help young people to get that essential first step on the employment ladder and allow them to build a relationship with prospective employers. From the employer's perspective, it allows them an opportunity to train and develop potential employees at a low cost and to bring in new skills to enhance their workforce. In order to facilitate the introduction of the National Internship Scheme, the Social Welfare and Pension Bill provides for a number of amendments to social welfare and employment legislation. The bill also extends to the existing stock of social welfare recipients the current requirements for new claimants to provide additional information that would be useful for profiling purposes to support people getting back into work, education and training. It is planned to implement enhanced activation arrangements based on a profiling system developed in conjunction with the ESRI, which will facilitate early targeted interventions for those who need them most, resulting in better outcomes and potential programme savings. I am introducing a number of amendments to both the state and occupational pension provisions in this bill. The most significant of these changes is the phased increase in state pension age to 68 years. The challenges facing the Irish pension system are significant. The population share of those aged 65 and over is expected to double, to more than double between now and 2050, from 11% to 26%. People, thankfully, are living longer and healthier lives, with average life expectancy set to rise even further in the future, up to 88 years for women and for some unknown reason only 83 years for men. In contrast, the share of the working age population is projected to decline gradually from 68% to 58%. There are currently 6 workers for every pensioner, and this ratio is expected to fall to less than 2 to 1 by mid-century, i.e. 2 workers for every person in a pensioner situation. Therefore, the task of financing increasing pension spending will fall to a diminishing share of the population who are at work. Spending on public pensions, that is social welfare pensions and public service occupational pensions, is projected to increase from approximately 5.5% of GDP in 2008 to almost 15% by 2050. Growing numbers of people want to work or may need to work beyond state pension age. Increasing the state pension age is one of the ways in which we can sustain the pension system, maintain the value of the state pension, and support people to remain in the workforce, as many people want to do. The approach I am legislating for today is for the gradual increase of state pension age to 68 years. This will begin in 2014 with the standardisation of the state pension age to 66. State pension age will be increased to 67 years in 2021 and to 68 in 2028. It is worth noting that until the 1970s, the qualifying age for pension was 70 years of age. The standardisation of state pension age at 66 in 2014 and the abolition of the state pension transition also removes the retirement condition associated with the state pension transition, which acts obviously as an incentive to leave the workforce and has been widely criticised as a barrier to older people remaining in employment. There is no retirement condition attached to the state pension contributory, which is currently payable from age 66. By gradually increasing the qualifying age for state pension, people will be further encouraged to remain in employment beyond 65 years of age. The numbers currently at work dramatically drop at 65 years of age. The quarterly National Household Survey showed that 77.2% of people aged 45 to 54 years were at work. This drops to 64.3% for 55 to 64-year-olds and to just 8.7% for people aged 65 years or older. For the future, arrangements are being examined which would enable people to postpone receipt of a state pension and receive an actuarially increased pension at a later date. In addition, changes are also being considered which would allow people with a shortfall in their PRSI contributions record at pension age to continue to make contributions beyond state pension age if they continue in employment or self-employment. The continued participation of older people in the labour market must be encouraged and facilitated to meet the challenge of an ageing society. Employees and employers need to be persuaded to change their attitudes to working longer. In the workplace, employers should try to retain older employees, and create working conditions which make working longer both attractive and possible for the older worker. Where this is not possible and people leave paid employment before state pension age, they may be entitled to apply for another social welfare payment until they become eligible for a state pension. Opportunities for older people to participate in education, in employment and other aspects of economic and social life must be maximised. Article 17 of the IORPS directive is designed to ensure a level regulatory playing field between insurance companies and pension schemes referred to in the directive as institutions for occupational retirement provision, which offer similar pension products. Insurance companies that offer pension products which underwrite death or disability benefits or which provide guaranteed benefits are required under the regulatory framework to maintain contain additional solvency margins. Such additional solvency requirements do not currently apply to institutions for occupational retirement pension provision offering similar products. The purpose of Article 17 of the IORPS directive is to ensure that institutions for occupational retirement provisions are required to meet the same additional solvency margins as insurance companies offering the same products. Chapter 2 of Part 4 of the Bill makes the necessary amendments to the Pensions 1990 Act to implement Article 17 of the Directive. However, it is expected that there will be few, if any, pension schemes in Ireland that function in the manner described in Article 17 of the Directive. The Bill contains a number of other changes to the Social Welfare Acts and to other enactments, some of which are simply clarifying existing legislative provisions. I would now like to outline the main changes involved. The Occupational Injury Benefit Scheme provides for a range of payments for people who are injured at work or who contract an occupational disease. Among the benefits available are pensions for the surviving dependents of a person who dies as a result of such an accident or disease, including pensions for surviving widows, widowers and civil partners, as well as for surviving dependent parents. However, with the development of the social welfare system over the year, the Dependent Parents Pension Scheme has effectively become obsolete. There are now only 3 people receiving this pension, with no new applications having been received since 1987. In the circumstances, Section 5 discontinues the Dependent Parents Pension Scheme for new applicants. Existing recipients will continue to be paid for the duration of their claims. Sections 6 and 7 provide for the necessary amendments for a phased increase in the state pension age up to 68 years by 2028, in line with the National Pensions Framework. This involves the discontinuance of the state pension transition, which is paid at 65 years, subject to retirement condition from the 1st of January 2014. The state pension age will be increased from 66 years to 67 years from the 1st of January 2021 and further increased to 68 years from the 1st of January 2028. The legislative changes being included in Sections 6 and 7 also fulfil one of the commitments to the IMF programme of financial support for Ireland that the previous government agreed with the IMF. Section 9 makes a number of amendments to the one-parent family payment to clarify the operation of the revised qualifying criteria for that payment following the change in the conditions to restrict the payment to families where the youngest child is under 14 years of age. The changes in Section 9 ensure that payment of the one-parent family payment will continue up to 16 years, where the domiciliary care allowance is being paid in respect of the youngest child. They also ensure that the general qualification criteria will apply to cases where one-parent family payment is retained for limited periods under transitional measures and in the case of recent bereavements. Section 11 amends certain means assessment provisions as a consequence of the abolition of the income levy and the health contribution. In addition, the provisions of the Family Income Supplement Scheme, which is calculated by reference to the net income of the family, are being amended to include the universal social charge in the list of deductions when determining the net income of the family. Section 14 clarifies the provisions relating to the allocation of personal public service numbers so as to allow parents and guardians to apply for PPS numbers for children under 18 years and to allow personal representatives to apply for PPS numbers on behalf of people who are unable to act, for example, because of a disability. Section 15 strengthens the provisions relating to the use of public service cards by providing for the cancellation and surrender of these cards where evidence becomes available that they are being misused. It will also be an offence to fail to surrender a public services card without reasonable excuse when requested to do so. Section 16 makes a number of amendments to the Social Welfare Code in order to facilitate the introduction of the National Internship Scheme. It extends to recipients of this new scheme provisions that deemed participants on the proposed skills development and internship programme, which was announced late last year, not to be employees for the purposes of labour legislation generally. Following advice from the Revenue Commissioners, the provisions deeming participants on the new internship scheme not to be employees will not apply in the case of the Tax Acts. Section 20 extends the list of bodies that are authorised to use the personal public service number for the purpose of carrying out transactions with members of the public to include the Probate Office and the Sustainable Energy Authority of Ireland. Section 21 amends the Corla Act of 2000 so as apply to the Citizens Information Board the standard provisions disqualifying people who have been nominated for or elected to the Oireachtas, the European Parliament or to a local authority from membership of state boards and agencies. This section also applies these standard disqualifications to staff members of the Citizens Information Board. These changes will apply to the Citizens Information Board in the case of anyone who is nominated for or elected to the Oireachtas, the European Parliament or to a local authority on or after the 1st of July 2011. Section 24 provides that Section 7 of the Official Languages Act 2003 does not apply in relation to this Act. This will enable any necessary orders and regulations that need to be made under the bill by early July, including the order to restore the national minimum wage to its former level, to be made without having to wait for the Irish translation of this Act to be made available. Tá mórchuid áilteanna sa bhile seo agus deirtear liom nach méid an leagan Gaeilge ar fáil le roinn seachtaine. Dá bhrí sin tá sé barta agéin áilt fithe chathair a chur chun cín chun a bheith cuinte de go naróigling an osfá náisiúnta a ardú ó thosach na Míosa. Tá astracán Gaeilge den bhile a réachtáil faoi láthair agus beag leagan Gaeilge den acht ar fáil an idirling agus a gló go garid, ní bheidh aon bhfuil ar sin. The text of this Act will be made electronically available in each of the official languages as soon as practicable after its enactment, and it will be published in a hard copy in both languages as soon as possible. Part 4 of the bill provides for the necessary amendments to the Pensions Act to implement Article 17 of the IORPS Directive. The substantive elements of Article 17 of the Directive are provided for in Section 35 of the bill. The existing provisions of the Pensions Act require defined benefit pension schemes to satisfy a funding standard by maintaining sufficient assets to enable them to discharge their accrued liabilities in the event of the scheme winding up. Where schemes do not satisfy the funding standard, the sponsors or trustees must submit a funding proposal to the Pensions Board to restore full funding within 3 years. This period can be extended at the discretion of the Pension Board. Section 35 of this bill builds on this process to secure the additional reserves required to implement Article 17 of the IORPS Directive by inserting a new part into the Pensions Act which provides for the application of the provisions of this new part to regulatory own funds schemes and to regulatory own funds trust retirement annuity contracts, subject to certain exceptions that are provided under Article 5 of the IORPS Directive. The preparation and submission to the Pensions Board of technical provision certificates by regulatory own funds trust retirement annuity contracts, a requirement for relevant schemes and trusts to hold additional reserves, and the amount of own regulatory funds required. The other measures contained in Chapter 2 of Part 4 of the bill make consequential amendments to provisions contained in the Pensions Act relating to regulatory own fund schemes and regulatory own funds trust retirement annuity contracts. These include, for example, the exemption of regulatory own fund schemes from the requirement to submit funding proposals or to restructure scheme benefits where a scheme fails to satisfy the funding standard under Part 4 of the Pensions Act. The requirement to submit funding proposals and to restructure scheme benefits is set out in a new part of the Pensions Act, which is being introduced by Section 35. In addition, Chapter 3 of Part 4 of the bill clarifies the responsibility of the Pensions Board in relation to the certification by the Board of certain policies or contracts of assurance as being suitable for pension purposes. Section 40 to 43 amend the Pensions Act to provide that such policies such policies or contracts of assurance will now require to be certified by the pensions boards instead of getting the approval of the board. And I want to inform the House that I intend tabling a number of amendments to the bill at committee stage. The Minister for Finance announced in the Jobs Initiative that the extension of PRSI liability to income arising from share-based remuneration would only apply to the employee element of the contribution and not to the employer PRSI contribution. Details of the operation of this measure are being finalised with the Revenue Commissioners, and I would intend bringing forward any necessary amendment to the Social Welfare Acts by way of committee stage amendment if the details are finalised within the time frame for this bill. I will also be bringing forward two further committee stage amendments. Firstly, to ensure that participants on the TOOS programme cannot concurrently receive a job seekers payment, and secondly, to align the commencement dates for the halving of the lower rate of employer PRSI contribution set out in the tables to Section 3 and 23, with the commencement date of the 2nd of July of 2011. I want to commend the bill to the House, and I look forward to an informed debate and to hearing your views on the measures contained in the bill over the next 2 days. In relation to the National Internship scheme, many employers have called for such a development, for an opportunity for people who are unemployed. This is an opportunity, I think, for everybody, whether in the private, the public, the voluntary or commercial sector, to give an opportunity, particularly to people who've qualified. It could be a qualified apprentice, graduate, postgraduate, somebody who has done specific training, perhaps to change their career orientation, to give them a foot on the ladder, a foot in the door, to actually get the vital job experience and to have and be able to present to an employer a CV. It's a system that has been used in many countries quite successfully. I have done a huge amount of work with a wide range of groups and bodies to ensure that this will be valuable work experience for qualified people, and as I said, to ensure that in particular people who have just not, in the current climate, not been able to get any work experience, that they will now be able to do this, and that will constitute, I hope, the first step for them in actually getting a job. The experience in many other countries shows that if people do a good internship, that is very often a route to permanent employment, even with the company with which they are interning. So I think that this is a very important step forward in terms of our attempts to give people, particularly people who found themselves completely unexpectedly unemployed because of the current crash, to give them an opportunity. And I want to commend the bill to the House.